If you want to sue a public figure for defamation in the United States, you have to prove something almost impossible: actual malice. This single legal standard, established in 1964, is the ultimate shield protecting creators, journalists, and everyday critics from bankruptcy. This is the story of two words that protect nearly everything you read, watch, and hear about powerful people in America. Two words that were forged during the Civil Rights Movement, nearly destroyed a newspaper, and are now under more pressure than at any point in the last 60 years. Those two words are actual malice, and despite what they sound like, they have absolutely nothing to do with malice at all. In 1960, the Civil Rights Movement was tearing through the American South. Sit-ins, marches, mass arrests. And on March 29th of that year, the New York Times published a full-page advertisement titled, "Heed Their Rising Voices." The ad was endorsed by some of the biggest names in America, including Harry Belafonte, Nat King Cole, Marlon Brando, and Sidney Poitier. It called attention to the violent suppression of black student protesters in the South, particularly in Montgomery, Alabama. The ad contained some errors. It said Martin Luther King Jr. had been arrested 7 times when the actual number was 4. It claimed truckloads of police had ringed the Alabama State College campus, but in reality, police had been deployed nearby without fully surrounding it. It mentioned students singing "My Country 'Tis of Thee" when they'd actually sung "The Star-Spangled Banner." Minor factual errors, but Montgomery's police commissioner, a man named L.B. Sullivan, saw an opportunity. He wasn't even named in the advertisement, not once. But he claimed the ad's criticisms of the Montgomery police reflected on him personally, and he sued the New York Times for defamation. The case went to trial in Montgomery before Judge Walter Burgwin Jones. The day before the trial began, Judge Jones attended a local Civil War festival where he personally reenacted the swearing-in of Jefferson Davis as President of the Confederacy. Some spectators at the trial itself wore Confederate uniforms and carried Civil War-era pistols. The case was decided by an all-white, all-male jury who awarded Sullivan $500,000 in damages, the largest libel verdict in American history at that time. Adjusted for inflation, that's about $5.4 million today. Sullivan's lawsuit wasn't an isolated event. It was a strategy. By 1964, Southern officials had filed 17 libel suits against media outlets covering the civil rights movement, seeking nearly $300 million in damages. Adjusted for today's money, that's just under $3 billion. The message to the press was unmistakable: cover civil rights at your own financial peril. The New York Times, facing the real possibility of bankruptcy, actually pulled its reporters out of Alabama entirely. Libel had become a weapon of segregation. But then the case reached the United States Supreme Court, and on March 9, 1964, the court issued a unanimous 9-0 decision that would fundamentally reshape American law. Justice William J. Brennan, Jr. wrote the opinion, and in it, he articulated a principle that has defined press freedom ever since. He wrote that America has a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. To protect that commitment, the court established the actual malice standard. From that point forward, a public official who wanted to win a defamation case had to prove that the person who made the statement either knew it was false or acted with reckless disregard for whether it was true or false. And they had to prove it with clear and convincing evidence, a much higher bar than the typical civil standard where you just need to show something is more likely true than not. Here's the crucial distinction most people miss. Actual malice doesn't mean the speaker was being mean. It doesn't mean they had ill will or bad intentions or a personal grudge. The Supreme Court itself acknowledged that the phrase is unfortunately confusing. What it actually means is this: did the person who made the statement know it was a lie, or did they have serious doubts about its truth and publish it anyway? Honest mistakes don't qualify. Sloppy journalism doesn't qualify. Even an extreme departure from professional standards doesn't automatically prove actual malice. The test is subjective. What matters is what the speaker actually believed at the time they made the statement. In the years after Sullivan, the court expanded and refined the standard. In 1967, the actual malice requirement was extended to cover public figures, not just government officials. In 1974, the court drew a line in Gertz versus Robert Welch, ruling that private citizens only need to prove negligence to win a defamation case, a far lower bar. And in 1988, in the famous Hustler magazine versus Falwell case, The court clarified that actual malice protections extend to satire, parody, and mockery of public figures. This framework created a tiered system. If you're a public official or a public figure, you face the highest hurdle. If you're a private citizen, the law gives you significantly more protection. Now, fast forward to 2023. Dominion Voting Systems sued Fox News for defamation, alleging that Fox had repeatedly broadcast false claims that Dominion's voting machines had been rigged to steal the 2020 presidential election. During discovery, internal communications from Fox hosts and executives revealed that many of them privately doubted or outright disbelieved the election fraud claims they were broadcasting. A Delaware judge ruled that none of the disputed statements Fox made about Dominion were true. On April 18, 2023, just as opening statements were about to begin at trial, Fox News settled for $787.5 million, the largest known media defamation settlement in American history. The case demonstrated that the actual malice standard, while difficult to meet, isn't impossible when the evidence is there. Around the same time, Rudy Giuliani faced a defamation lawsuit brought by 2 Georgia election workers he had falsely accused of election fraud. A jury awarded them $148 million in damages, later reduced slightly to $146 million. Giuliani reached a settlement with the plaintiffs in early 2025. These cases prove something important. The actual malice standard doesn't make public figures defenseless. What it does is demand proof, not suspicion, not outrage. Proof that the speaker knew they were lying or didn't care whether they were. But the standard is now facing its most serious challenge in decades. Justice Clarence Thomas has called it a policy-driven decision masquerading as constitutional law, arguing it has no basis in the original text of the Constitution. Justice Neil Gorsuch has questioned whether a standard designed in 1964, when news passed through layers of editors and fact-checkers, still makes sense in the age of social media, where anyone with a phone can publish anything to millions instantly. And in political circles, there's been growing pressure to weaken libel protections, with calls for new legislation targeting media outlets. But here's the structural reality that often gets overlooked. There's no federal libel law. Defamation is governed by state law. Neither the president nor Congress can simply rewrite those rules. And the Supreme Court, for its part, has repeatedly declined to take up cases that would allow it to reconsider the actual malice standard. As recently as March 2025, the court denied review in Wynn v. Associated Press, with only Thomas and Gorsuch dissenting. Defenders of the standard argue that weakening it would unleash a chilling effect on journalism. Justice Brennan himself wrote that, "Erroneous statements are inevitable in free debate and must be protected to give freedom of expression the breathing space it needs to survive." Without Sullivan, the threat of ruinous libel suits could silence not just major newspapers but independent journalists, bloggers, commentators, and activists across the political spectrum. The protection, after all, isn't partisan. It shields right-wing media just as much as it shields left-wing media. The actual malice standard was born in a courtroom where spectators wore Confederate uniforms, and a judge reenacted the inauguration of Jefferson Davis. It was created to stop powerful people from using the legal system to silence criticism. And for 60 years, it has served as one of the most important safeguards of free expression in American law. Whether it will survive the next decade in its current form is one of the most consequential open questions in constitutional law today.